That has not, because my first order was breach of contract. Talk to Mr. Mueller. There was extensive, oh my goodness. That is not true. That does not say what you say.
Thanks, Your Honor, because
Oh, counsel. You
But
are
Your Honor,
not telling me you filed it last night, are you?
we had a week to reply to
We
this.
still have a week left.
You have a week? You get to file a reply the night before the hearing? What rules are you following? I'm sorry, I'm lost. What rules? What you have a week after the hearing to what are you talking about?
No,
I'm missing. You don't file a reply at what time did they file it? 5:06 p.m. last night, counsel? No. The rules do not allow that. I'm done. I'm sorry. This is really frustrating.
Your Honor,
I
am
can't
so
believe
sorry.
you're saying, I'm sorry.
This,
I can only do what I can do, counsel. That is totally an untimely reply.
Good morning, Your Honor. Let's go on the record. We have John Moore versus Derrick McCall, 818-772-979-C.
Okay, and who's making an appearance for Mr. Moore?
Laura Ungaro from Craig Mueller's office. Ungaro, Ungaro. And Catherine.
I'm sorry, how'd you spell your last name, Laura?
UN, like Nancy, G's and George, ARO, bar number 4482. And
Thank
Catherine,
you. Okay,
Thank
you got the bar number? Okay, thank you very much. And next to you, I think, is Mr. Moore, right?
Yes,
I've had
yes.
several hearings on this case. All right. Welcome, Mr. Moore. All right, and who is here for the defendants? Mr.
No, wait,
Hamilton?
Your Honor.
No, Moore?
Yes, on Moore.
Catherine Ramsey, bar number 8109, also present. Mr. Mueller's
I'm
tied up
sorry.
in a preliminary hearing.
Okay, I'm sorry, I can't see you, Miss Ramsey. I didn't mean to cut you off. You're not in there you go. Okay, I didn't mean to cut you off. I'm so sorry.
We have all three of us in the conference room, so we tried to stay 6 feet apart, but it's not going to work with one screen. So I put you so far away to get all three of us. But Craig is tied up in a preliminary hearing in North Las Vegas, so I am familiar with the facts. Laura did a lot of the legwork on the writing of it. So we're both here representing Mr. Moore today, if that's okay, Your Honor.
So, absolutely, no problem. I appreciate you doing it. No, and I didn't. It's the limitations of technology. It's great to some extent, but being in the courtroom, is still better. Can I say? But at least we're going forward. Okay, thank you, Catherine. So I have both of you. Did we get Mr. Hamilton online? Is he
Yes,
here?
Judge, I'm online, and I don't know if you can see me or not.
I can. I see you with your mask on.
Yeah, and Judge, I also have here defendants Miuccio and McCall with me,
Okay.
and they are also masked.
Okay, well, that's all. You're not 6 feet close to me, so whatever you feel comfortable with, you are more than willing to do, Mr. As long as I can hear you. I've had issues when people wear masks too, and I can't understand you. If I can't understand you, I will. You don't have to. I will ask. Okay, thank you.
Okay.
All right. So also appearing is Maria. I want to say the name right. Miuccio.
Miuccio.
Miuccio. Okay, and Derrick McCall. Correct.
Correct.
Okay, well, we're ready to go. I've got, starting with, the first thing that was filed is defendant's motion for summary judgment on the three remaining claims. I guess really, we can start with that, although plaintiffs then filed what they called a motion for reconsideration on the other case that I did, the other ruling on the contract issue, and also a motion for leave. But I'll start with defendant's motion for summary judgment on, after my last ruling, I left claims for conversion, unjust enrichment, and intentional misrepresentation. All right, correct? I think I'm right.
That's correct, Your Honor.
Okay, I'm familiar with the case. All right. Okay, so let's start with unjust enrichment. You feel the argument by defendants is there's no genuine issue of material fact that if the defendants take the property back, that there is no unjust enrichment or nothing, improvements or anything that Mr. Moore was responsible for since he's been occupying the premises, correct?
That's correct, Your Honor, and I can speak to that briefly if you'd like.
Okay, well, my understanding is basically where we where you focused on was the Pioneer Air putting in a new air conditioning unit, HVAC system, correct?
That's correct, Your Honor. Plaintiff had made multiple representations to the court that he'd spent $7,000 out of his own pocket. That turned out to be incorrect. He actually received the HVAC unit as a gift, and he did so and had it installed in violation of the lease that he had entered into, which provided that he was not supposed to make any alterations to the property without first getting the go-ahead from Mr. McCall. And so in the middle of this lawsuit that concerns who is the rightful owner of the property, he goes ahead and has it installed. And then there's just one other point that is important to note on the unjust enrichment claim. It's that this is a claim that goes to the equities that are at the heart of the case, Your Honor. And all the while that this case has been pending, the plaintiff has not been paying the sewer or the waste bills, so he's not been maintaining the property. And in fact, because of his failure to maintain and pay those bills, there was a notice of intent to lien on the property. So when it's all said and done, Your Honor, it's our position that this claim, that's a claim of equity, fails.
But wouldn't that go to, if it's equity, whether he had the ability? Because I did read the opposition saying, since he was not the legal owner of it, he wasn't getting notices of certain things, etc. Wouldn't that basically go, if I allowed the unjust enrichment, to whether there was or was not any damages? And his violation of the lease, I looked at it. I also looked at the lease, and the defendants have a duty to make sure that the unit was habitable, as we know. And if the air conditioning unit was not working at all, I don't know, and I'm just saying that could also be considered a breach of the lease. But I'm not really looking at to whether affirmative defense to unjust enrichment is he broke the lease. What I have to look at for purposes under the certified fire protection versus precision construction, was there a benefit conferred by Mr. Moore onto the property if this property does go back to the defendants? That's where I would focus on the unjust enrichment. On the argument that he didn't incur it, it is still, I looked at it and there was an air conditioning unit for, even if he had got it cheaper than the fair market value, or even if he had gotten it free. And I read the letter from the Pioneer that basically said, hey, he can't qualify for paying it in installments. We, because of his veteran status, are going to do it free. I did say, they said, if we'd known you were involved, I understand all that, we might have talked to you and maybe your people would have paid for it. But they didn't. That wasn't done. And so to me, even though he got it free, that air conditioning unit still would be considered an enrichment of the property. So how that would work out by the trier of fact, honestly, how it would work out, Mr. Hamilton, when the trier of fact gets through hopefully gets to the facts that we can kind of focus down to for the trier of fact, that would be up to them. So I am denying the motion for summary judgment. I feel there is a question of fact as to whether he can maintain an equity claim on unjust enrichment for the property. The conversion, I totally agree with you. And when I did the conversion claim, I did it based on, because I know you can't do conversion for a real property. And of course, I know quite a lot about the statute of frauds and oral contracts because I was involved. You weren't here, but I was involved. I don't want to say intimately, exclusive? I don't know. I was involved substantially in the arguments on the contract issue and statute of frauds. The reason I did the conversion and left it was for the property because, and then I don't know how that will shake out because during the filming, there was certain, furnishings in the house. And then when he went to move in, the furnishings weren't there that were part of it, but yet, and I apologize, one of the musicians, I forget that, I'm not good at names like you guys are maybe, but one of the musicians then took him took Colleen consignment and then furnished the house with that. I don't know how how that evidence will all work out to the trier fact, but I'm very clear, there is no conversion for the property. There is a conversion on the furnishings, and I don't know, and as you know, the case multifamily development versus Crestel is there. It's a question of fact. I don't know how that will work out on the evidence. I don't know the difference between, or if they have evidence, you know, all this has to be proven by evidence, as we know, when you get in front of the trier of fact, the value of what he got or what came into the house from Colleen consignments and what was originally in the house. I don't know the proof on all that, but that's the reason I'm denying that. I feel there's still a question of fact on the furnishings. I want to be as specific as I can since this has been extensively briefed. I'm trying very hard, Mr. Hamilton, maybe you figured it out when you look through this file, to focus what exactly is going to be still a claim and how for the trier of fact, which is, I very much appreciate all the briefings because it allows me to do that when we started with the original motions and then the summary judgment. So I want to make it very clear. It's for furnishings only is the reason I'm denying it, and based on the furnishings.
Judge, if I may,
Yes.
there's been no evidence produced. There's been no evidence produced from the plaintiff as to what furnishings. I mean, this is a brand new theory that they're bringing up in their opposition to our motion for summary judgment. So they've not adduced any evidence as to what furnishings they're even claiming that were
It was
converted.
the furnishings. Have you seen the video?
I've seen the video, Your Honor,
It's
but
the furnishings that they
had-
were, at least my understanding, maybe I'm incorrect because I've looked at the video too again and again. When he is told about the house, then, and I apologize, I can't remember which person spoke about, and these furnishings that are all used, and you could see furnishings in the house. I assumed that's, not assumed, that's from the status of the record. Like I explained, that's what I thought would be the furnishings. Maybe plaintiff's counsel can speak to it, and maybe I'm reading more into it, you know, because I've looked at the video and stuff and gone through the complaint. Whoever, Ms. Ramsey, whoever wants to address that, I would appreciate it. Or Ms. Ungaro, who wants to address it? Because on the issue, on the conversion, on the proof you're going to give that there was conversion on furnishings.
Yes, Your Honor, this is Laura Ungaro. Yes, that's exactly what we are saying. There was a conversion on the furnishings. He was given the furnishings when they awarded him the house, the free house, and all the furnishings. And Miss Miuccio was taped saying, "John, this is all yours. Look at the sofa, look at the couch, look at the pool table. These are all yours." It's on the video. We have provided the court the videos, and obviously counsel has seen those videos. That's the conversion that we're speaking of. We're not talking about conversion of real property. That's not even possible, but there's a conversion of the personal property that was given to him. When he got there, it was gone. And yes, B. Taylor, the musician that you're speaking of, did take him to Colleen's and buy him a whole house of furniture because he said, "This is," I realize this is hearsay, but he had told him.
But that would be an off, or I'm going to say the word offset, that would be included as to whether those furnishings in the conversion, what the loss was from the conversion. And that's all an evidentiary matter for the trier of fact. So, and
Yes.
I know Mr. Flangus and the other man, Mr. Barnaby, am I doing this? I'm pretty sure when we talked about the conversion, that's how I interpreted the conversion was the furnishing. So from those original motions for some, but I appreciate giving the chance to clarify it so all counsel can know where we're going with this as far as the trier of fact and what will be relevant at the trial. Okay, so I appreciate, but I am going to deny it. I feel there is the summary judgment. There's a question of fact for the trier of fact. Are we at a jury trial? I can't remember, or a bench trial. We're a jury
We've
trial?
asked for a jury.
I'm sorry?
It's my understanding that we asked for a
It's a
jury.
jury trial.
Okay, I have so many cases, I wasn't sure. And people are converting to bench trials now since we can't get jury, but whatever, okay. Whoever the trier of fact is, that will be a question of fact for the trier of fact. Okay, intentional misrepresentation is the third claim that I left. And plaintiff is arguing that the plaintiffs had not produced any evidence that Ms. Miuccio's statement was false or knowingly false, correct?
That would require proof by very significant evidence.
I want them to be present, and I want to be able to see them through these proceedings.
You both did a good job bringing all this to my attention.
I'm going to make a record about you in a minute. You need to sit down and be quiet.
The court finds in the best interest of the minor child and makes the following findings.
For the record, I don't say these things to hear myself talk.
An absolute decree of divorce is granted.
By September 6th, you will pay $6,000 of what is due.
Which obviously is an element of intentional misrepresentation.
That's correct, Your Honor. And
Okay.
it's worth noting that this is a claim that requires an even higher level of proof. And there's been absolutely no evidence that any statement that any defendant made was knowingly false at the time the defendant made it. And for that matter, there's also been no showing of any damages. Mr. Moore has lived in the property for over 3 years, paying virtually no rent, and it's unclear at this point how he could possibly have been damaged by that. So, Your Honor, without just any evidence showing that the defendants made a false statement, this claim fails right out of the gate.
Okay, so did Ms. Miuccio say that at the time she did the representations or statements on the video that that it was her intent to transfer the house at that point? Has she testified? I looked for that in the deputy. Has she testified to that?
Your Honor, and that's another issue. the plaintiff has not taken any depositions in the case.
Okay, so I have to go on, well, that's how people do it. I can't address that. I could do a lot more, Hamilton, but I can't address that. But what I have to look at is what it is. If so, then that would have to be addressed. That would show that she didn't knowingly make a false statement. But when you, okay, plaintiffs, I apologize. I think I know too many facts here. Plaintiffs, how would you address, because when I look at the facts, obviously, whoever the trier of fact is going to see this video, if she's going to testify at trial that at the time I meant to do that, whatever facts changed or whatever circumstances changed so that it wasn't knowingly false, and then yes, that is a fact that could defeat their claim for intentional misrepresentation at trial. But right now, when you look at it, and they have the evidence, and it's in front of me because it was an exhibit to several of the motions that she says this is yours, and then he did not get the house, as we know. He got a rental agreement. That would still be something that would be a genuine issue of material fact at the time. So whether there are damages from it, that's a whole nother thing. As you know, you have to prove up to the trier of fact if your answer at the time for the trier of fact, hey, even if so, where's your damages? I guess they're going to argue the damages. I didn't get my house. You knowingly, now what did that lead, without sufficient and intent to induce his reliance, the damages come from his reliance, which is what you're speaking to, correct? You're saying, wait a minute, where's the damages if he relied on it? He's been living in the house, what is it, $1 a year, right? And you said in your motion he hasn't even paid that $1 recently, correct? Okay, but that goes to whether a trier of fact would find damages. I can't determine that at summary judgment stage. But
Your Honor,
do you want to address? I'm sorry, I don't mean to cut you off. I'm really interested. Tell me.
Yeah, Your
Mr.
Honor.
Hamilton, tell me more. I do not mean to cut you off. This technology is not easy.
All right. That's quite all right. Your Honor, they still have the burden to produce some evidence. Instead of just giving us naked assertions, they still have to produce some evidence at this stage that there was a knowingly false statement made, and that it was knowingly false at the time it was made. They have not done that. All they do in their opposition is, first off, they say it was a knowingly false statement because she told them, A, that they first had to enter into a rental agreement. But they provide no evidence as to how that's false.
Well,
which is their burden. It's their burden to provide that evidence, and we certainly don't.
I agree with that, but what they have provided to this court is the tape that shows that she gave the statement to Mr. Moore, this is yours. This furnishings is yours. This house is yours. Now, and then that didn't occur. I certainly think a trier of fact at the time can say, wait a minute, that didn't occur unless there's something to explain. She meant it at the time, but something occurred afterwards. There's certainly evidence now in front of me that there's a genuine question of fact, whether it was false, because it didn't occur. Instead, a rental agreement occurred a week later. I mean, I understand there's a lot of facts. I've tried to, I'll be honest, Mr. Hamilton, I've tried as best I can to zero in on the facts where we can. But as you know, my burden under summary judgment is a tough one, as we know, if there's any genuine issue of material fact. And I'm one that, as a judge, I try very hard to make sure there is a genuine issue. But Ms. Ungaro, do you want to address what I'm saying? Do you tell me if...
Captain Ramsey, and I will...
Ms. Ramsey, you tell me.
I will address it, Your Honor. On the intentional misrepresentation, you are correct. We do have a video, and there is no mistaking what she said and what she gave him. Here, the house is yours. Everything's yours. This pool table, this furnishings, the whole bit, and the house. And then they take him to some back room and make him sign some kind of a rental deal instead. So they knowingly misrepresented at the time. And we've been forthcoming and honest about both things from the onset. Here's a video, here's a rental agreement, they don't match up. Was he given a house to live in for the rest of his life? Here's a house, you can live in it. They don't tell him how long it's going to be. When someone's given a house, you get a house, you get it. That's his damages. He changed his position in life to move into this house. He could have 3 years equity somewhere else by now. He's not able to do that because of this case. He has been damaged on that. So that is for an issue of trier of fact.
And I agree, as I said, we all know the three elements from I assume we all know the elements from Nelson versus Her, that there was a false representation that is made with either knowledge or belief that it is false or without a sufficient foundation. 2, an intent, which they have to prove to induce the other person's reliance. And then the damages, they have to prove up what happened from that reliance. So I am denying that. I feel there are questions of fact that still need to be determined by the trier of fact on that. So I am denying that summary judgment also. Okay, the next one is, I interpreted it as plaintiff has a counter motion for me to reconsider the order on the contract issue. Is that correct? In the opposition,
Yes,
there was a counter motion for reconsideration. Correct?
Yes,
and that's
yes,
I pulled my order here, but I have my order. The one I worked on with Mr. Barnaby gave me. Correct?
Yes, sir.
Oh, I have it. It was Mr. Barnaby. It was entered or filed. I have to do that correctly. 5/4/2020, and it was the findings of fact, conclusions of law and order regarding defendants' motions for summary judgment and motion to expunge unlawful list pendants. And plaintiffs want me to reconsider that. Correct?
Yes, Your Honor, please. We have new facts that we brought before the court that we only discovered at the last hearing on the defendant's motion for summary judgment. So with that, we are armed with new facts. We are armed
What new facts?
The new facts are that Mr. McCall, while sitting next to the plaintiff at the defendant's table in court, and before the court was engaged in a colloquy with Mr. McCall's counsel, and during that time, Mr. McCall became very frustrated and apparently blurted out that they intended always to sell the house to the studio when the network picked up the show, that they never had any intent, parenthetically, they never had any intent to give away the house. It was just going to be used.
Okay, so what does that have to do with the oral contract? That may be evidence on the intentional misrepresentation. How does that assist with the statute of frauds and the oral contract?
Because
even if that's true, I don't know what happens in court. I mean, obviously, I don't know. How would that in any way be new facts that would change my rulings on the contract and the statute of frauds?
Because the oral contract that the plaintiff is discussing that we would request the court reconsider has to do with the oral contract for furnishings, number one, and number two, for his term to stay in the house, how long he was staying in the house and under what conditions.
Okay, slow down. Can you slow down a second? Because now you're changing. This is not what was argued. If you look at the pleadings on the summary judgment, I know you didn't do it, Mr. Mueller did it. If you go back, the oral contract was for the house. You're now saying, well, we should have an oral contract for furnishings?
Well,
and an oral contract for what?
There was an oral contract. This whole situation basically is an oral contract. They gave him orally, they gave him a house and contents. And
okay, so what you're arguing, what you're saying is, at the time that I granted summary judgment, you can't get the land. I'm sorry, I'm not redoing the statute of frauds. I was very clear on it. I'm not. So what you're saying, you think it is too broad, that there still should be an oral contract for the furnishings, which is
Correct.
actually
That's-
addressed by the conversion claim anyway, correct?
Yes, Your Honor.
But because, and an oral contract for, what was the next thing you said? You said two things, I'm sorry.
The second one is, what did they give him? We know that they did not give him title to the house. What we want to find out is exactly what did they give him? Did they give him a house to live in for the rest of his life? They still use him every day on the web, on the internet. It's everywhere. It's all over the press. It's all over everywhere that they use his likeness and his life as their brand for heroes for heroes. And he's used all day, every day, today, years after all this happened. The question is, what did they orally give to him? What did they agree to do? They agreed to use his license as is evidenced in basically what's a personal services agreement, characterized or denominated as a rental agreement, but is no more and no less than a personal services agreement. And it allows him to stay in the house. In that personal services agreement, it can be terminated. It's supposed to be for the term of the year, and we understand that. But at the same time, they continue today to use his likeness and his life for their own benefit on the internet. And that's all day,
So
every
what you're
day.
trying to argue is they had an oral contract to not use his likeness?
No, I'm arguing that they have an oral contract
To do what?
with him. Number one, for the furnishings that the content.
I got the furnishings. I'm going on to the next one. I'm trying to
And now
follow you better.
Next thing is, and I think this is a question for the trier of fact, is exactly what did they give him in terms of living arrangements? Did they give him a house for life? What did they give him? We know they didn't give him title.
No, for the trier. No, the trier of fact doesn't get to decide what they gave him. I have to decide what legal basis they had, and then they decide the damages from that. They don't get to say, hey, trier of fact, I think they gave him a house. They don't get to do that. That's not how it works. You have to give me a legal basis, and then they can decide the damages from that. So that argument I'm not following. I guess what you're saying, and it was not argued that way before, was, hey, there's also a surviving oral contract for the furnishings, which was also addressed in the conversion cause of action that was left. So what you're saying, and I'm looking at my findings, because I can tell you, you weren't there. This was not in the pleadings the first time. So then my answer is, wait a minute, you're now coming up with a new oral contract that you didn't argue, plaintiff, in the first motion, or it certainly didn't appear to be by me, which I knew about the furnishings. That's the only reason I left the conversion claim. Can I be very honest? But it wasn't argued and I'm looking at my findings of fact. I considered arguments that because the causes of action were dismissed, that title to the property could not, well, it was all title to the property argued. It cannot be conveyed through conversion, unjust enrichment. Because if you look at my first finding 5, I said plaintiff cannot prove an exception to the statute of frauds pursuant to NRS 11.210 subsection 1, the first, second, third, and seventh causes of action for breach of contract, breach of oral contract, breach of covenant of good faith, fair dealing, and for specific performance. Where's the complaint? I'm going to pull up the complaint and see if what you alleged in that complaint, did you just allege the property? I guess I need to go there, right?
Your Honor, so far,
what did you allege in those causes of action? If the allegations were only the real property, which is how my recollection it was argued. Huh? Yes, I'm sorry.
You are
I can't hear you.
100% correct in every word that you've said. What we're asking the court today is for leave to amend our complaint. And we've sent in a proposed second amendment.
Okay, but your leave to amend, you wanted to add a conspiracy, a civil conspiracy, and a RICO action. Did I miss that you wanted to amend to add? Let me finish, because I've worked really hard trying to get this separated. Are you in your motion for leave to amend? Let me pull up, asking now to amend it for an oral contract for the furnishings?
Yes, Your Honor.
Okay,
That's
I read everything. Let me look at your motion. Did I miss that? I certainly, so let me look. So,
It's,
okay,
it's in the amended complaint, Your Honor.
I'm sorry?
It's in the amended complaint.
Okay,
The causes of action in the amended complaint.
Okay, well, I looked at your argument, so let me look at it. I'm trying very hard to make sure let's see.
I believe
Leave
it's the
to
first
amend, I got it here. The leave to amend, copy, oh, not a prejudice. Oh, what it says here, and I'm reading word for word from page 24 of your motion. Comes now plaintiff John J. Moore, by and through his attorney of record, Craig Mueller of the law firm of Mueller, I'm sorry, I know Craig Mueller, and Associates, and files the following motion for leave to file a second complaint in the amended complaint in the above captioned manner to add additional causes of action for civil conspiracy and civil RICO.
You're right, Your
That's
Honor.
what it says. That's what it says in your motion, and that's what I addressed. It doesn't say, so what you're saying is I should have then looked for other causes of action in your proposed second amended?
Your Honor, I please, in my ignorance, I failed to include the ones that I was asking for reconsideration on. I'm sorry, I didn't put them in there.
And I'm not trying to find fault. I'm just trying to figure it out the best I can, as you can imagine.
Well, I'm trying to do it right, Your Honor, and obviously I didn't.
Okay, so let me see. Let's look at the proposed second amended complaint. Because I'll be honest, I looked at the case law on RICO and civil conspiracy, because that's kind of how I do things. Okay, let's see. Then better.
And Your Honor, while you're
looking, my law clerk's helping me. It does say breach of oral contract.
Your Honor.
I did not.
Your Honor.
I'm sorry.
Your Honor,
hold on a minute. I'm sorry.
Miss Ungaro, if you could just please stay at arm's length away from the speaker.
Move farther back because it's echoing.
Yes, it's echoing. Just stay, yes. Thank you.
Okay, so let me look at this because I went by the arguments. So you've got a first cause of action for breach of oral contract. Let me see what it says. Contract. Okay, and you've got an implied covenant of good faith and fair dealing on the second. You already had conversion. I don't know why. Why did you want to change the conversion? Oh, you just wanted to include it. Okay. Unjust. Yes. Okay. So how do we know you incorporate in your breach of, you incorporate paragraphs 1 through 68? Where is it that you talk about the furnishings as being an oral contract? In your one, let's see, tell me in 1 to 68, so this defendant would know that's where you were coming from.
Which pleading are you looking at, Your Honor?
I'm sorry?
Which pleading are you looking at?
I'm looking at all I can look at is your proposed second amended complaint right now. I looked at your argument. And I looked at RICO and I looked at civil conspiracy. You're now saying, Judge, we also now want to do an oral contract for the furnishings. And I'm trying to look at your allegations so that this defendant would know you're not doing the real property transfer. You're only looking for the furnishings. So where and you go 1 to 68. So I'm asking you in the allegations of 1 to 68, where is it that this defendant is on notice that the oral, or this court is clear that the oral contract only refers to furnishings? That's what I'm looking for.
Okay, Your Honor, Captain Ramsey here. Ms. Ungaro will look at that right now. I also want to make note that on page 3 of the opposition and motion for reconsideration, on lines 15 to 17, we do identify those new claims that we're requesting for consideration on there. It just didn't get put into the conclusion portion that you read earlier on page 24, but they are identified on page 3, lines 15 to 20.
Well, I just read your, okay. Do it again. On your motion, I just read your motion. Where did you identify it?
Page 3.
It doesn't, no.
On page
Okay.
3, there's paragraphs, lines 14 to 20. I'm going back to
I'll
something.
keep looking at it.
Sure.
No, what you're asking for, the defendants, you're asking me to reconsider the oral contract, but not to add it to your amended. All this said, which is what I understood, it says here, John Moore respectfully submits that defendant's motion for summary judgment on plaintiffs is properly denied, which we've addressed, and requests this court reconsider its order, which I already cited to the order myself, its order regarding breach of oral contract, breach of implied covenant of good faith and fair dealing, and allow plaintiff to include, the counsel, I'm reading it, and allows plaintiff to amend his complaint to include claims for civil conspiracy and another for violations of civil racketeering, influenced and corrupt organization act RICO. It does not say there that you're asking me to amend for an oral contract for furnishings. It does not say that. I'm missing your, help me, what did I misread here?
I was just looking at where we asked the court to reconsider its order. That's what I was looking for the language for.
That has not, because my first order was breach of contract. Talk to Mr. Mueller. There was extensive, oh my goodness. That is not true. That does not say what you say.
Okay.
So what your argument to me now is I should have looked at the proposed second amended complaint and looked at your causes of action that you did not put it in your motion, correct?
Apparently so, Your Honor. I'm sorry.
I'm just trying. I do read everything, so is that where we're at right now?
No, Your Honor, yes, the way I worded it probably was improper. And when we look at lines 14 through 20, I think that I made the assumptions that I was asking you to please reconsider your ruling on the breach of the oral contract. I should have said with regard to the furnishings, because we all know that you can't have an oral contract for an interest in real property. So I made assumptions I should not have made.
You do know that was not argued in your original motion for summary judgment, just, I hope you know that. Go back and, whatever.
I can't argue that with you.
All right, so all I can do is try to figure out what it is in front of this court to try to do this as best I can. So wait. Okay. So my question is, I just am looking at in your proposed second amended complaint. Help me to make sure I want this fair to the defendants. Where does it say that the furnishings talks about the furnishings? Why don't we start with that?
Okay,
I'm starting on page 3 under general allegations, right? Is that the good place to start? Yes.
Yes, Your Honor, it is.
Okay, that helps me.
Yes, please.
No.
When we state the facts that in the general allegations,
Right.
and we
Tell me
get
about
down
the furnishings.
I'm looking for them.
Okay, I'm sorry. I'm not mean to push you. It's your time to have a complete record. So
if you want to check, if you would like to look, Your Honor, on page 416.
I've got it in front of me.
Okay.
Which I have 416. Mm-hmm.
Yes, Your Honor. And then start with paragraph 32, 33, 34, addresses the furniture.
Okay. Meanwhile, was pointing at while saying, this is your couch, this is an all, okay, paragraph 34. Okay, so paragraph 34 says, Miuccio, meanwhile, was pointing at the furniture while saying, this is your couch, this is your pool table, all this yours, we just gave you all this. Okay, that talks about the furnishings, okay.
And that's all on video.
No, I've seen the video. Okay, so that's basically, and then you have under 37, the video clips being given the property. You don't say real, if you look at paragraph 37, you don't say real or personal property, but you say generally given the property can be viewed, so that's incorporated under 37. And same with 32. Okay.
I would respectfully submit then that the video speaks for itself when she's pointing to the furniture and the couch and the pool table.
I agree. That's proof. I mean, that's a fact. I'm just trying to make sure. Okay. All right. So when you do the first cause of action for breach of oral contract, okay, even though you don't specifically, which I am going, I'm going to talk to Mr. Hampton, but if I allow that, I want that breach of contract, the first and second, to specifically refer to the the furnishings. Otherwise, you're going around my summary judgment on property, and I will not do that. That's not fair. This needs to be explicit so these defendants know what specifically are the legal causes of action.
Yes, Your Honor. I got it. I see exactly what you're saying. It was my error.
I'm just trying to make it as fair, not fair. I'm trying to make it as legal.
Yes,
correct.
I want it to be legal and fair as well. I want it to be right.
I know. Okay. So first cause of action. And the next one is the second. Okay. All right. So let me look here. So I'm looking at, so you want, I will tell you right now, I am not I am denying your motion to reconsider regarding my order. Oh, I've got so much, let me find it. Where's my order here? My order and filed 5/4/2020 on findings of fact, conclusions of law, and order regarding defendant's motion for summary judgment and motion to expunge unlawful list pendants, as that addressed the contract issues regarding the transfer of the real property. I want to make sure there's no new evidence regarding that, and there's no change in the law, so I am denying that. I'm now moving on to your motion to amend the complaint, to add, so now we have, you want to add an oral contract and implied covenant good faith deal regarding the furnishings, in addition to this RICO and the civil conspiracy, correct?
Yes, Your Honor.
Okay. All right. Mr. Hamilton, I've read it. I know I've sincerely read everything on RICO and civil conspiracy. And I know you got caught. I don't know. Did you respond as an oral contract? I didn't pick it up in your opposition, or your reply, but maybe I missed it.
Judge, they didn't argue that, and so
okay.
As the court correctly pointed out, I can't read their minds. I had no idea that that's what they were going to come in here and argue today. But in any case, they don't even allege that there was some bargain for exchange to get the furnishings. And if I understand what they're trying to argue today, Judge, there's no basis.
What you're doing is the consideration argument. I understand that they used that same, the defendants went through that same consideration argument, even if on the oral if you had gotten around this, if they had not violated the statute of frauds, I don't want to be specific how I say that, there was extensive briefing on the consideration. Their answer was they used his likeness. I'm sure you've read it all too. So I do find there's consideration. So I will do, okay, let me do this, Ms. Ungaro. Let me address what I did do. On the civil conspiracy, let me get my notes. I did not find an unlawful act, that there was conspiracy to show an intent to commit an unlawful objective for purposes. Even looking at all the allegations, I did not find any factual allegation to support a civil conspiracy with they committed, well, it's called an unlawful objective and as you know, to amend, I have to look to make sure it's not futile, which is one of the standards especially at this stage, that tends to be an issue that should be addressed by this court. I didn't see anything that would be considered an unlawful act in your allegations to support even a civil conspiracy claim against these defendants?
Your Honor, I am basing on the cause of action for civil conspiracy on the fact that there was never any intent on the part of the defendants to ever do what they said they were doing. That is misrepresentation. In this,
You got that. You already have that. You got an intentional misrepresentation claim. But if you read the case law, an actionable civil conspiracy arises where two or more persons undertake some concerted action with the intent to accomplish an unlawful objective for the purpose of harming another and damages resulted. What was their unlawful objective?
the unlawful objective was that they made him a victim of their scam, where they were saying that they were giving away homes to veterans for free. Later evidence indicates that they had planned to give away 60 homes to veterans, and yet they never did anything. This was the first of their scams. They had already offered the house to Jason Brooks, and Jason Brooks was the first on their list of
So you don't have any of that in your pleading. You don't have that in your allegations. Where is that? You're bringing in fact. I have to decide a motion to amend based on the factual allegations in your pleadings. Where is, I didn't see that.
Throughout all of these pleadings, we have discussed it in depth and great length about this was a concerted plan by McCall and Miuccio to get a reality show going at the expense of our client. He was going to be their victim. They were engaged in a scam that they were perpetrating on the veterans community here in Clark County, at least. I can speak to
Tell me in your general allegations where you use the word scam, where you say they were going to do 60 other homes this way. All the stuff you just argued to me, show me starting on page 3 of 16 where those allegations are in this proposed second amended complaint.
I didn't use the word scam because it's rather inelegant to say that.
And you got to find an unlawful act. You're using it now to argue to me that's an unlawful act.
Well, that's shorthand for everything that I've written out here, that they told him they were doing all these things with no intent ever to do any of it.
To be respectful to you, Ms. Ungaro, I get that. That's why you have your intentional misrepresentation claim. I totally understand that. I mean, I know these facts as much as I can, but my question is where in page 3 of 16 do you have an unlawful act asserted? Because these defendants have a right. You have to, for me to allow you to amend it, you have to have factual allegations that this court can look at to say a trier of fact, if it was true, as you and I know. I'm just at this point trying to see if I would allow you to amend, because I still have to look at the futility that what they did was in some way unlawful.
Your Honor, if you would grant us leave, I will amend this complaint to say exactly what I just told you and then some.
Okay, so right now I'm going to deny your motion to amend for a civil conspiracy without prejudice. So if you have allegations, I can only look at the reason you have to attach a proposed complaint, which I did look at for the RICO and civil conspiracy, is based on the allegations. So right now I'm going to deny your motion to amend based on the factual allegations asserted for civil conspiracy, and RICO's even more. I pulled this 37 crimes you have to have for a RICO action under NRS 207.360.
37 crimes
related. I'm sorry? RICO? Your next one is RICO, right?
Oh, yes, Your Honor. I misunderstood you. You said 37 crimes. We only need 2 predicate crimes.
No, I'm saying they list all what can be included. I didn't say you have to have all 37. No, I've done RICO claims, counsel. I'm a little smarter than that. but you have to have one of them asserted under RICO to make it a crime, a criminal intent to make it part of the racketeering, because I'm familiar with RICO, correct?
And my attempt
There's
was,
nothing even close to that in your complaint.
okay, my attempt
I
was
looked at it for that too.
to apprise the court that we believe that the conspiracy to commit the unlawful act of scamming my client is one of the predicate acts. And the second one is the fraudulent misrepresentation as part of the scam as the second predicate act.
And that makes it a crime related to racketeering?
Well, Your Honor, when I went down the list of elements for RICO, this situation, in my estimation anyway, fit every single solitary of the 11 elements that we needed.
What? I have no idea what you're referring to. I know that when I looked through it, you have to have the intent to further racketeering activity, correct?
Mm-hmm. They did. They
okay,
had
and you're right. Your racketeering is going to be based on their intentional misrepresentation, correct? And now
yes,
what you think you're going to do
it's
a civil conspiracy to scam.
Yes, Your Honor. I have, starting in paragraph 110 of the, on page 12 of 16, on the proposed second amended complaint.
Okay.
Okay.
I see the civil RICO. I read it.
Okay. They conspired to steal the furnishings, and they fraudulently misrepresented to Mr. Moore that they were giving him a house, all the while knowing that they would not. And even after telling him, giving him, and publicizing it, memorializing that they were giving him a house and contents, they didn't do that. And then McCall and Miuccio, acting together, because we have to have two or more people, they engaged in these crimes of theft.
What crimes?
And fraudulent misrepresentation. Theft of the furnishings.
Intentional misrepresentation is not a criminal crime.
Fraudulent,
You've got an intentional misrepresentation claim. I'm not. You can't rely on intentional misrepresentation as that they were engaged in racketeering activities.
But Your Honor, this was part of the overall scam. He was just.
I don't know that, counsel, because that's not in your complaint. You're asking me. I don't know. You don't. I can tell you. I carefully looked at your civil RICO and civil conspiracy, and based on the allegations in this proposed, is it second amended complaint? I want to make sure I don't do it wrong.
You're 100% right on everything.
No,
Your Honor.
I believe me, I can mess things up easily here with so much paper. I am not. I found I would not allow you to amend based on that.
Okay. Would you accept amended complaint with regards to the other proposed causes of actions as alleged, and permit us, please, leave to file an amended complaint under NRCP 71, I think, including facts.
No, I'm sorry.
We want to also be able to include the facts for the civil conspiracy.
My law clerk is showing me something. Yolan, I'm so my law clerk wants to show me something on racketeering from something you just said. So let me just look at it real quick, okay?
Thank you, Your Honor.
Okay, here's what my law clerk just showed me under a case. What your argument, what's the case? Saragossa versus Brown. The court concluded that to satisfy the definition of a pattern of racketeering activity, a mere showing of two criminal predicate acts would not suffice. Rather, the plaintiff must show both relationship and continuity, that the racketeering predicate crimes are related and that they either constitute or threaten long-term criminal activity. And that's that's cited in one of our cases there, right? So your argument to me of the two predicates, so here's what I'm gonna do. I'm denying your motion to amend the complaint at this time for racketeering, and RICO and civil conspiracy based on the proposed amended complaint, without prejudice. I'm not going to have you leave, because then I have to look at whether I'm not going to give you leave, but you can certainly file it and I will address it. On the oral contract issue for furnishings, at this time, if you want to amend the complaint to just specify that the oral contract and implied covenant good faith dealing is related only to the furnishings, I would allow that.
Thank you, Your Honor.
That's it. Okay?
Thank you. Yes, Your Honor. Thank you.
Thank you, counsel.
Your Honor, if I may be heard on that.
Sure.
Your Honor, the time for leave to amend is long past. And Your Honor, the plaintiffs came into court today having written one thing in their moving papers, then confronted with the law and the facts showing that it just didn't work. They call an audible today and try to change everything. Your Honor, we weren't on notice of these things. Discovery is closed. Plaintiff, and it's their right, but plaintiff did not do any discovery. There's not going to be any additional discovery at this point to even support those claims. So, Your Honor, we would respectfully submit that that leave to amend should be denied, and that civil RICO and civil conspiracy should be denied with prejudice, Your Honor.
I am denying it at this time. I'm not going to do it with prejudice. If they file it, I will address all it. What's your new scheduling order? Did it have anything? Was it all done before the coronavirus in March?
It was, Your Honor. This case has been pending since 2018.
No, 1231. My law clerk just pulled it up for me, because none of that was argued either, too. So it said in here, all parties shall file motions to amend pleadings or add parties on or before September 20th, 2019. Can I ask, counsel, is that the only one you've been given? You have not amended any of your scheduling orders? I have like so many cases, I don't have it memorized. Do you know, is that the one in effect right now? Because I know you were set for a trial, right? Yes.
Your Honor, that's the operative scheduling order.
Okay.
And so we're now a year past that, and claims are being raised that have no basis in fact because they didn't do any discovery, and they're now seeking to amend those claims.
Okay. I want to look, because that's a new argument too, so let me think it through. All right, counsel.
Your Honor, respectfully, we did raise that argument.
I apologize, Mr. Hamilton.
We did argue that in opposition to the leave to amend. We did point out that they're a year late in moving to amend.
Okay, that's the I'm sorry, I got so many papers here. Let me look. Was it in the reply or in the original?
It would have been in our opposition for their motion for leave to amend, Your Honor.
This one. Okay, hold on, I'm pulling it. I tended to look at substance, new evidence. No, that's the reconsideration. Here's the racketeering. You do have it was late. You do. In the beginning paragraph, I went after the substance. You have plaintiff's motion seeking is late by a mile. The deadline to amend the pleadings was September 20th, 2019. And then you went into, I didn't focus on that. I focused on the RICO and the substance.
Fair enough.
Yeah, I'm the first one to, I focus more on the substance. So the deadline, okay, and under the rule, okay, so how I look at that, did they have enough information by, what's the date? 2019 to file the RICO, the oral contract to include furnishings, et cetera, and the other? They certainly did. They didn't have any new evidence. So here's what I'm going to do. I am going to deny the motion for leave to amend as being untimely pursuant to the scheduling order of, hold on, let me get it. 12, that was filed December 31st, 2019, as the deadline was, hold on. The deadline to amend was September 20th, 2019, and I find it untimely. And I also find that the information was available to them at that time to have done it timely. There is no, there's no newly discovered evidence that they would not have been able to amend it within the time limit.
Your Honor, the newly discovered evidence comes from February 20th at the February 2020 hearing. That's the newly discovered evidence that we didn't have at the time that the discovery cut off in September. So as we addressed
newly discovered evidence, what Mr. McCall said in court?
Yes, Your Honor, and we addressed that in portion 2 of our reply about him withholding that information that directly impacted the liability. So that's why we're asking the new.
I'm sorry. You're saying the newly discovered evidence, and where did you argue that? Where did you argue that, counsel?
That is argued, Your Honor, in the pleading that's before the court today. Our reply to the defendant's opposition is on page 4 of 8.
Where is their reply? I'm trying not to lose. I know, I may not. Where's her reply? There's the opposition. Where's their reply?
It was filed, Your Honor, this was.
Wait, I don't have a reply in front of me by you. In fact, I asked today, when did you file a reply?
It was filed last night, Your Honor, because
counsel.
But
You're
Your Honor,
not telling me you filed it last night, are you?
We had a week to reply
We
to
still
this.
have a week left to reply.
Yes, we still have a week on this, and we managed to get it in on time last night for this hearing.
You have a week? You get to file a reply the night before the hearing? What rules are you following? I'm sorry, I'm lost. What rules? You have a week after the hearing to what are you talking about?
No.
I'm missing it.
From their opposition date.
What do you mean from their opposition date? Your reply date is due, even if it's untimely, you can say it's untimely. Or here's what you do. You ask for leave of this court to file a reply. You don't file a reply at what time did they file it? 5:06 p.m. last night, counsel? No. The rules do not allow that.
Both motions were heard together. We didn't know this motion was going to be mashed in with the other motion. We were only anticipating the motion for summary judgment, not anything about the amendment today.
It's your counter motion.
Right.
So I did it. The reason it was heard at the same time you filed, you could have done a separate motion. It was your counter motion, counsel. That doesn't even make sense by the rules. That's your counter motion.
Yes, and in their opposition, in the defendant's opposition, they raised the issues that we had to address in the reply. This was the reply to.
Okay. I'm just shocked that you didn't even bring this up today. I don't know what other judges do, but I actually read things ahead if you can't tell. If you had started today and said, oh, by the way, Judge, because I asked my law for a reply as late as 5 o'clock last night because I read everything and you had not filed it. We actually got on Odyssey. If you had started the hearing today and said, hey, Judge, by the way, did you get the reply we filed at 5:06 last night? You're now telling me, and how long have we been in this hearing?
I absolutely. When I sent it to be filed, I presumed that it was going to be in your file. At no time did I ever.
Oh, ma'am. Do you know how the courthouse works? You presumed? How would it get in my file? How was it going to jump into my file? That's.
I don't know how.
That's not a fair argument. Now, what most people do is they bring over a courtesy copy, or at least email me, or at least before they start the hearing and say, oh, by the way, Judge, we filed it. I'm done. I'm sorry. This is really frustrating.
Your Honor,
I can't believe you're saying, I'm sorry. I can only do what I can do, counsel. That is totally an untimely reply.
Your Honor, I'm sorry you didn't get to reply.
6. So here's what I'm going to do. I don't know what it says. I have no idea.
My profoundest apologies, because I spent the entire day doing this so that it would be on time on this, knowing that I still had another week to do it in. I still wanted it to be before the court.
What is the other week? I'm losing it. How did you think you could file a reply a week after I have the hearing? I'm losing it. I don't understand it.
Well, this hearing should have been scheduled out. It should have been continued to a later date, is the reality of it.
Okay, then when did you request that?
We asked for the hearing. A hearing was requested when we filed the opposition to the defendant's motion for partial summary judgment on the remaining claims and the counter motions for reconsideration, that pleading. We put right on there, hearing requested.
Well, of course, because you put it within the motion in your opposition. They are related. You could have easily filed, Counsel, I can't look, the face you're giving me right now, I don't appreciate, so I have bent over backwards, Counsel, to help you. I will tell you for the record, I did not read a reply that was filed at 5:06 last night. There was no one asking me for continuation. It's now in the record, so now I'm going to read it because it's not fair. So what I will do is I will go ahead and continue. Is the reply basically based on your motion to amend?
No, Your Honor, it addresses the defendant's opposition to
Let me ask again. Opposition to, let me ask it again, Counsel. Please listen to what is your reply regarding your motion to amend your complaint?
Yes, Your Honor. It's motion.
That's all I need to know. Thank you. Obviously, you did it in opposition to your, that's all I'm asking, ma'am. Okay. So what I'm going to do is I'm going to continue the motion, plaintiff's motion to amend complaint, so I could fairly read the reply until when? I'm going to look at my calendar right now. When can we get it on? Because it's in the record. You take your time. They're the ones doing it. Here's gracious. That's September. This thing. Do that. Do it then. Okay, here's what we're going to do. You have a status check, and ma'am, can I speak with you? Sorry, you're making a court appearance. You have a status check on September 29th. What time are those at? 11? 9 a.m. So I'll continue your plaintiff's motion to amend the complaint till September 29th at 9 a.m. And then I can have the opportunity, in fairness to this court, because to read the reply that I had not heard about until 5 minutes ago. Okay?
My profoundest apologies. I would never do anything to be disrespectful to the court or to make your life any more difficult than it is. I am very sorry that you didn't get this. I
just do not understand how you thought I would get it. I'm sorry. Do you understand how? Maybe you should, Mr. Mueller will explain it to you. Even when you file it, it doesn't mean that it's put in Odyssey for 24 to some hours. Here's how it works. And there is an EDCR that you are to give us courtesy copies. To this I'm here. I was here all day yesterday, or at the very minimum, and I get coronavirus is tough. I get it, everybody. I'm working hard to try to do hearings and stuff.
I'm not blaming it on anybody but myself.
Okay, so what has happened, because things are getting filed late, they will tell me at the beginning, because I hope you know I read everything and I want the opportunity to read it. I will not make a ruling when something is filed in a case and I haven't read it. I will not do that. My frustration is if you had said that and put me on notice, hey, by the way, Judge, I filed this and I left at 5. I wouldn't have seen it anyway, to be honest. I literally talked to my law clerk saying, is there a reply? I can give her an affidavit here because I was looking for it, ma'am, because I do realize people file things at the last minute and it wasn't there. But here's why anything that's in the record, I want the opportunity to address. I'm not going to shoot from the hip. I want to do it fairly to all parties. My frustration is and just the limitations with the filing is tough, and I want to read everything. So, if you can't tell, I'm not looking for fault. I'm not looking for fault from anybody. All I want to do is have the opportunity to read everything so I know I am doing the very best I can. Does that make sense? Same with
for sure.
the oral contract thing. I would bend over backwards for the defendants as much as for the plaintiff to make sure I'm doing it as fairly as I can, but I need and I'm one that wants to look at the law and think it through, as you can see. So but no, I cannot get something. And once again, if you had said that to me, I would have then continued it. But that's just, I'll just tell you, as far as judges, we work really hard to read everything. And there is not a perfect system to get things here. I know because of coronavirus, people aren't giving us courtesy copies anymore, because I used to always, when I come in the morning, look in my bin if a courtesy copy had come over, because I used to file things late. I was a practice. I get it. It's tough. So please do not think I'm finding fault. But in fairness to everybody, I'm going to continue that. I'm going to have you on for a hearing that day, and I'll try to do it, be ready for it, and we'll do it when you do your status check. So it's fine. I hope I didn't act frustrated.
No, you're wonderful.
It's very difficult with the limitations. So if I act frustrated, I apologize. It's just, if you file something, I will not get it. As much as there's just no physical way I would have had it.
Your Honor, I think it's Catherine here. I do apologize for the confusion. It looks like that our office gave Mr. Hamilton an extension on the opposition that put the dates behind. So when he filed his opposition on the 11th, they calendared this reply to be due not till the 18th until we realized what happened. And that's why Ms. Ungaro filed it yesterday. So
okay. I appreciate that. Because Ms. Ramsey, how would I have known that?
I know.
I don't even have, if you guys do stipulations outside the court, I have no idea. I just know I have to go by the EDCR rules, and that's all I can do, to be very honest. And I had a lot of hearings on today, so that's what I couldn't understand what she was saying. But thank you, I appreciate it. I'm like, am I just not understanding the 8th Judicial District Court rules?
No,
thank you for that clarification.
We granted him an extension, and that's what put our dates behind by that time frame. So
okay, and once again, the court would have no way of knowing that, and once again, I try to hear things all at the same time because it makes sense, doesn't it? I try not to piecemeal it because it's all interconnected, and I truly know I do a better job when I do it all at the same time. So I appreciate that clarification, Ms. Ramsey. I really do, because I kind of felt like I was just missing it, and I don't want to do that. Okay, we will see you back for that. Any questions on the other rulings? Mr. Hamilton, I'm going to go ahead and read the reply, and then someone will be here anyway for the status check, so I'm not inconveniencing anybody. You're going to come to court anyway, and we'll just put it then. Okay?
Judge, can I ask a couple of questions on your ruling of the summary judgment motion? Just the main summary judgment motion, Judge. If I understand your rulings,
back to the beginning, okay? Mm-hmm.
Yes, Judge. Putting everything together, it appears from your rulings that defendant or plaintiff cannot get the actual real property back, but the most that he would be able to get at trial is money damages. That's my
You're
understanding.
going to have to sit. No, I'm not going to sit here and make a ruling like that, Mr. You need to look at the causes of action, what the evidence is, and what the elements are, and you can do that. I'm not going to say that in court, no. But obviously, you can see for the conversion, I was very specific on that. If you look at intentional misrepresentation, you can see what the elements are, what they have to prove on reliance, and you can explain that to your client. And you know the evidence more than I am. So I'm not going to say something like that. That would be inappropriate on my part. But yes, I made the rulings. The elements are what they are. And what evidence can prove those elements they have to prove, you certainly are aware of as much as they are.
Certainly, Your Honor, I understand. And the only thing that I was trying to go with that is that at this point in time, the plaintiff is still in the property. It's been over 3 years, and my clients would like to get the property back.
Well, then we need to get a trial set, and we can get it done. I had it set. Mr. Hamilton, I understand the inequities on both sides. Is that a fair way to say? I understand it. I mean, I've know these facts. I understand that completely. I had the trial set, I'm pretty sure, within this time frame, didn't I? Or whatever. It did. When? During COVID. And I understand that. I get everyday phone calls. When can we do trials? June 8th I had it set for specifically for that, Mr. Hamilton. After I did the summary, I worked hard on the motions to dismiss and the summary judgment to get it into the position so we could do the trial in June.
Well, we appreciate your hard work, Judge.
I'm not fishing for. I get it. I just want you to understand. I get the frustration on everybody's side and the courts. This is tough right now. I mean, not being able to do jury trials, and then it opens up a lot more motions and stuff. Believe me, I think the practitioners have it harder than the judges. You guys are in a tough position, and I truly understand that. And litigants want it over. The worst thing in the world to me is things to drag on, because I've learned from cases they don't get better, do they? They only get worse for everybody. They don't work. Now, you know what? I have it down as a bench trial. Maybe I did it wrong. I don't know if I ran that by the count when I was talking to Mr. Mueller. I'm doing bench trial. What?
That's right.
I don't know. The way Odyssey does, one spot in the file says jury
How
trial.
about we look at it and we'll look at our records, and we'll look at it for the next court hearing. We can clarify.
Okay, because it is a status check, because I am doing bench trials. What I do on bench trials is I'm trying to require at least counsel to be in the courtroom if you're uncomfortable, right? I don't care if witnesses, because I've been doing a lot of evidentiary hearings, but if the counsel isn't here, oh my gosh, you guys, you can't believe how hard it is when counsel isn't here. What is that? Oh, there you go. Here we go. We just pulled it out. I thought it was a bench trial, and I couldn't do it back then, but I can. Here's what it says. If you look at an order that was entered 2/26/2020, there is an amended order setting a civil bench trial and a firm trial setting. I even gave you a firm trial setting, you guys, that was entered, and you were set for June, right? Okay, you were. I mean, if you want to do a bench trial,
we're fine.
You don't have to, but I can do those. I've just been setting some. We need to get this amended complaint and stuff that organized, but and yeah, my only concern is I do find it difficult not to have counsel in the courtroom. I don't care if you wear masks and stuff. I'll do anything I can to make sure we're all comfortable, 6 feet apart, and anything that you feel comfortable on the COVID. I don't want to make anybody uncomfortable. I don't mind at all. If witnesses come virtually, if you bring, it's just very difficult if the whole bench trial is virtual. It takes I've tried it. It's really I've tried it with evidentiary hearings, counsel, and it's really tough. Does that mean it just really makes things difficult? But if you're not, I'll work with you. I'm under the administrative orders. I can do bench trials now. That last one we just did it. 20. It doesn't matter. Administrative order 20-17, page 16. I can go. It's up to the judge's discretion. I'm more than willing to work with you on this. If you're comfortable, I'll do whatever's comfortable for your clients and you. Once again,
comfortable coming to court with the mask.
We'll be in court, Your Honor. We'll be there.
We're ready and willing to go for a bench trial as soon as the court's available.
Okay.
So we'll have a status.
Can I ask a few simple questions? I don't know if you guys. How long? How long do you think it will be? I'm trying to schedule them now because a lot of people are opting for them because we don't even, like I said, they're going to start. Well, you even agreed to it. But I think I got Mr. Mueller, and I don't know if Leo Flangus was still there, or I don't know. I'm sorry, Mr. Ham. I'm not sure. But I remember a discussion where I thought a bench trial, only because I know so much about the case and I'm trying to be fair, would work. And obviously they must have agreed to it, or I wouldn't just change it to a bench trial on my own. I don't remember, Mr. Ham. We've had quite a few courts. I don't know. But I know they would have agreed, or I wouldn't, or talk to you. Do you still want to do it? I don't want to think I'm pushing you, but
I believe Mr. Mueller did agree to it. I do remember it happening in February.
Okay, well, please, because I would have never put an order if we didn't. And honestly, I can't remember if it was Mr. Leo Flangus or I don't know. I don't have I guess I could look at my jabs. It doesn't matter. Okay, how long do you think?
2 to 3 days, Your Honor.
I was going to guess 3 days.
And let me ask that, do you mean full days starting at 9 in the morning until 5 at night? Or I have calendars, I have court hearings Tuesday and Thursday. If I gave you all day Monday, maybe half a day Tuesday, and then Wednesday, would that work?
Judge, from defendant's perspective, that's ample time.
Yeah, I'm just trying to figure out, okay. Because I have hearings, as you can see, Tuesday and Thursday at 9. But I don't, Monday is Chambers calendar, I'm okay. Monday, okay. When is that status check? 29th. Okay. So let's do this. By the 29th when you come, because that's a status check on trials, I'll try to see if I can come up with a time frame for you. How about that?
Thank you. We'll have our calendars ready.
Yeah, please have your calendars ready and talk to your clients and witnesses.
Okay.
Yeah. Here's what I do, that you can call your witnesses virtually if you want. I don't mind you putting them on the stand because I assume your clients will, it's up to your clients if they want to be here or not. I'm fine if they're here. We'll take all precautions. They can testify virtually or they can testify here in the courtroom. I will make sure that I do the best I can to make it COVID
friendly.
I don't know if it's friendly. I don't like that word, you guys. COVID, I don't know. COVID, I don't want to say safe either. I don't know. Oh, I'm sorry. My marshal just told me the word is COVID compliant. That's right. We have COVID compliant. That's what we're doing. Because I've been doing it because really a bench trial is just a bigger evidentiary hearing, a larger one. Okay, so if you will please come up dates and I'll do them on the 29th. We can move forward, which I sincerely want you both, all of you counsel knowing clients, that has been my goal since day one on this case. I please believe that. Okay, that would be great.
Your Honor, thank you for your time and your preparation. It's truly appreciated.
You're very welcome. And once again, see you the 29th. Like I said, this case is, I've done some, I really want it fair to all the litigants. Anything else you need, Mr. Hamilton?
Judge, I just want Judge, I just wanted to confirm the Liz Pendens has been expunged.
Yes.
That was.
No, I'm sorry. I don't know. I haven't. Hold on, my law clerk's looking at it.
It is not.
No, it's not.
Oh, no, we denied it because I said it depends on who gets the house. So you're right. Let's get this trial. Right?
Okay.
No, I did not because there's still well, hold on. Mr. Hamilton has more arms than. It was denied. Okay. But then I think what we need to, here's the other thing. When I do a bench trial, I have an order where you have to give me the briefs. You have to give me the law, right? And findings of fact. So, and based on where we're at now. Well, we'll send it to you, but come up with a date, okay? Be as many flexible as you can, because I can give you I'll give you a Monday, half day, Tuesday, and Wednesday, and I would really like to do it to help. I'm more than willing to schedule you if you want to do it.
Okay.
Because it is within my discretion under that administrative order. As long as you all are comfortable, I'll schedule it.
That's great.
Thank you.
Okay?
Thank you very much,
Give
Your Honor.
me. Okay, we'll see you the 29th, and I'll then read the reply and do the motion to amend.
Thank you,
Okay.
Your Honor.
Thank you.
Thank you, Judge.
Thank you, counsel, so much. I appreciate everything.
Thank you.
You're welcome.